If you're just joining us, I want to welcome you to the webinar on professional independence. I am Kelly Testi, the CEO and Executive Director of the Association of American Law Schools, and it's my pleasure to welcome you today and thank you for joining us. This has been a six-part series that we've conducted on professional independence, and today is the last session. And we are so pleased to welcome Harvard Law School's Center for the Legal Profession to conduct this session. I want to let you all know that ALS is always trying to help the legal academy and the legal profession get stronger and work for excellence. As you all know, we are the Learned Society for Law Faculty, and we also are a membership organization for law schools that share our commitment to excellence in legal education. In addition to webinar series such as this, we are also the conveners of the ALS annual meeting every January, a large conference for clinical law faculty, a conference for new law faculty that'll take place very soon, and then also convenings like this that help tackle the critical issues of the day. And this is one that is both urgent and important as we all see vast change to the legal academy, to law itself, and to the legal profession. And today we couldn't have better conveners for this important topic than my friend, Professor David Wilkins from Harvard Law School, who is here to be the moderator of this program. And so, David, I want to thank you for your engagement, and the center has long been a source of my great admiration for its leadership. So thank you for all you do to help us understand the evolving legal profession. I'll be happy to turn this to you now so that you can take the program forward. Thanks for joining us.
Thank you, Kelly, and thank you for all you are doing at the AALS, but quite frankly, all you have done and all the many positions that you have served. You are a true leader of our profession, and quite frankly, a role model for some of the kind of independent thinking that we want to talk about today. In any event, I am David Wilkins. I'm the faculty director of the Center on the Legal Profession here at Harvard Law School, a proud member of the ALS. This is my 40th year of teaching, so the one thing I'm not is young anymore, but that means a little bit. I've had a chance to see the evolution of the profession, and I've spent really the last 40 years trying to study that evolution. And today we want to talk about what the implications of that are for professional independence. I'm going to share some slides here, mostly so that I remember what it is I'm supposed to be saying. So let me see if I can do this seamlessly here. That looks like it's actually working. And I'm going to put this in slideshow once I can get the thing about these controls, there it goes. So we go to, why is not that working? Let's try, here we go. From current slide, there we go. All right. And I'm gonna try to set the stage a little bit for the next 20 minutes or so. And then we have a terrific panel to engage in a conversation about some of the issues that I hope to raise here. So I call this presentation The Profession, the Market, and the State, Reimagining Professional Independence for a VUCA World. For most of you who know, that's volatile, uncertain, complex, and ambiguous. And that is certainly where we are today. So let's get started. Why isn't this? I need to click on this. All right. So here's kind of who we are and why it matters for what we're going to talk about today. The Center on the Legal Profession, as I said, I've been the director now for more than 30 years. And our mission is really three things, right? Conducting and sponsoring and publishing world-class empirical research on the profession, something that really isn't a major focus in law firms the way it is in, let's say, business schools or in other professional schools. We try to work on innovating and implementing new methods of teaching, both for lawyers and for practicing lawyers. And then, in addition to directing the center, I founded the law school's executive education programs, which were really the first of its kind in a law school environment, now ably run by my former student, Scott Westfall. And perhaps most of all, we try to provide opportunities for what we call bridging between the practitioners and the academy. And I'd say one of the biggest trends, as I think most of us would agree, since certainly I was a law student, has been that the academy and the profession have really grown further and further apart. And that makes both sides poorer, in part to try to understand complex issues like we're going to talk about today. If you're interested in learning more about us, check out our website, where we have a whole variety of information, and including a digital magazine called The Practice you can subscribe to for free, which comes out 6 times a year, and tries to tackle issues like the one we're going to talk about today. Okay. Um, I want to say a little bit about the current crisis, but then to say there's much more than that. I think, listen, the terrific other editions of this series and of the work that's being done by the AALS and many others has focused a lot around the unprecedented attacks on lawyers by the Trump administration, and the idea that these pose a really immediate and existential threat to professional independence. But if we step back, we see that the threats to traditional ideals of professional independence predate this administration and really are not confined only to the actions of government. I mean, most of us, or many of you, will remember this famous statement by Judge Stanley Sporkin about the Lincoln savings and loan crisis, where he wondered, even though Lincoln had some of the most prestigious law firms representing it, that nevertheless massive fraud was undertaken. And he said, where were the lawyers? And what he's really saying is, why weren't these prestigious law firms willing to stop their client from this kind of reckless behavior? And we can go back much longer than that to see criticisms and worries about lawyers' professional independence. In fact, there's a great book by my friends Bob Nelson and David Trubeck and Ray Solomon called Lawyers' Ideals and Lawyers' Practices, in which they document that concerns about professional independence are almost as old as the legal profession itself. And this should be a tip that there's something deeper going on than the current political environment. And I want to say, I believe that's because independence is really difficult to nail down exactly what we mean by that. And it has at least 4 different meanings, right? There's the one we often talk about, independence from the state. The idea here is the criminal defense lawyer or the civil liberties lawyer willing to stand up for the rights of individuals against the state. But we also want lawyers, in some sense, to act independently for the state as officers of the court, of the social curators of legalism, as my friend Bob Gordon once said. And we also want them to be independent from their clients, like in the Kay Scholler Lincoln Savings and Loan case. And poor Kay Scholler gets the rap for this, but there were many, many other top law firms who were involved. And the question is, are they willing to say no to their powerful clients? But we also want them to act independently for their clients, to be fiduciaries, to put their clients' interests above themselves. All right? The thing is, those are a lot of meanings, and they're often in tension with each other. And the image is of kind of a professional completely insulated from all the the pressures of the world. But unlike high priests or philosopher kings, lawyers are also expected to act in the world and quite frankly, to be paid for doing so, increasingly, as we have seen, quite handsomely. So that makes independence difficult to define and difficult to achieve, but it's also why independence is so important. Look, we're about to celebrate the 250th anniversary of this great country. The part of what I'm saying here is in an essay for a book that Harvard Law School faculty are putting out of small essays around the 250th anniversary. And, if we are going to be, as we often say, a country of laws and not of men, lawyers play a critical role in the functioning of democratic institutions. It's also true that lawyers are central to preserving individual rights in a world in which those rights often depend on access to law. And our economy is increasingly legalized, in which the workings of the economy require lawyers to play an important role. And they are also not just supposed to facilitate the economy, but they're also supposed to be gatekeepers, meaning they are responsible for certifying that the actions of private actors and public actors comply with the letter and the purpose of the law. And in all of these areas, we depend on lawyers exercising independent professional judgment as a core element of what we think of as the rule of law. So we've been trying to understand this set of relationships within the context of what we have come to think of as what we call the micro level gearing of the legal system and the overall macro level structure of the system. We came up with this framework as part of a large global research project we did called Globalization, Lawyers, and Emerging Economies, or GLEE, as we like to call it. My friend David Trubeck came up with that name. I don't wear a tracksuit and I don't sing, but I do study how is the market for legal services evolving around the world and the important rising powers. And it was out of this framework where many countries were gearing their legal framework that we came up with this idea of the relationship between macro and micro level gears. And a very simple way of thinking about it is at the micro level, at the level of the profession, we have lawyers, we have clients, we have legal education. But this sits in some ways underneath a structure of an organized bar, of a market, including a market for legal services, and state actors in which lawyers operate. And part of what we were trying to understand in the GLEE project, and partly what I hope will be helpful here, is what's the relationship between these macro gears on top and the micro gears at the bottom? The traditional answer, and the one that lawyers have given for more than 100 years, is self-regulation, right? The only way to achieve, for individual lawyers to achieve, this kind of delicate balance of all these different kinds of independence that I talked about is to allow at the macro level the bar to control its own affairs. That is subject to kind of light oversight by the judiciary. I mean, yes, ultimately lawyers are subject to the jurisdiction of state Supreme Courts, but state Supreme Courts are members of course, all lawyers themselves. The bar would be able to control who practices law, including preventing non-lawyers from entering the field, how law is practiced, including enacting formal rules of professional conduct, control over the process of enforcing these rules, and the education and certification of those allowed to practice law, and policing and negotiating the boundary between what is acceptable professionalism and what is acceptable market activity, which for most of the bar's history included limiting that market activity, strict restrictions on advertising, restrictions on the ownership and structure of legal organizations, and even how legal services would be bought and sold. There used to be not just maximum prices lawyers could charge, but minimum prices lawyers could charge. And individual lawyers, as well as clients and the public and law schools, were all expected to defer to how the bar at the macro level structured these relationships. And in return, lawyers promised to provide independent professional services in the public interest or for the public good. That's the traditional model, and everyone who's a law professor or a law student will be familiar with it. We sort of express this in the gearing metaphor by the idea that the legal profession gear is sort of turning the rest of the macro level, which is then creating a micro level in which lawyers, beholden to the professional bar, are in charge. But to be honest, this has always been more myth than reality. Right. First of all, lawyers have always been market actors. They have always sold their services in the market. And we haven't even had the kind of pretense that the English barristers have, where the barristers don't touch the money, the solicitors give the barristers money. We've had a profession in which lawyers directly engage in market transactions with their clients. Moreover, since the 1960s, at least, this market is becoming increasingly competitive, right? Just look at the number of lawyers. It's gone from less than 250,000 in 1960 to 1.3 million today. And look at the way lawyers practice. It's gone from a profession in which 70 or 80% of all lawyers were in solo or small firm private practice to one in which most lawyers work in some kind of professional organization of increasing size. And that's not just in the private sector, it's in government law offices, it's even in legal services organizations, plaintiffs' law firms. Whatever the organization is getting bigger and bigger. And many of these organizations have adopted explicitly market norms and practices. And even in the non-market side, like government and NGOs, lawyers are increasingly subject to bureaucratic norms designed to enforce institutional goals. Many market restrictions, moreover, have been invalidated or eliminated by courts, by government agencies, sometimes even by the bar itself. So there are no longer any restrictions on advertising and many other forms of commercial expression. And clients have become increasingly sophisticated through the internalization of legal expertise at the corporate level, or even at the individual level, have much more access to information, and in all sectors are seeking to hold lawyers accountable, both privately through the market, but also through the courts in terms of malpractice and other forms of liability. At the same time, bar organizations like the ABA, but this is true really across the board, have declined significantly in membership and authority, while attempts by other forms of regulation at the federal and state level have increased. So today, most people not in the legal profession don't know that fewer than 25% of all lawyers belong to the ABA. It was more like 50% in 1976 at the time of the bicentennial, for example. And the bar, its authority in many areas, like the selection of judges, where the ABA used to give accreditation, which or sign off on the competence of potential judges, which carried significant weight, is no longer asked to play that role. And even in legal education, the formal control over law schools has been taken away from the ABA. And it's fair to say that the ABA formally and the profession formally exerts far less influence over legal education than it once did. And if we look at other forms of regulation, whether that's the SEC or the IRS or other forms of governmental agencies are increasingly stepping up, or at least attempting to step up their efforts to hold lawyers accountable for violations of what these government actors think of as their gatekeeping duties. And so you're left in a world in which, yes, the profession's understanding of its norms and practices remain important. I'm not trying to say the organized bar and the formal legal profession isn't important. Lawyers are also increasingly subject to a broad variety of market pressures reinforced by increasingly sophisticated clients that oftentimes are more important in shaping lawyer conduct than the formal norms or rules or practices of the bar. So, again, back to our sort of simplified chart, we now see that rather than the legal profession driving the macro level, it's the market more and more that is doing so. And it's clients who are driving the micro level, particularly at the corporate sophisticated client level, not lawyers anymore. And the market is becoming increasingly more complex. So, first of all, the market for lawyers no longer consists of just lawyers, right? Instead, as I've written before, there is a whole ecosystem of legal service providers, many of which are not controlled or operated by lawyers. We still call them, quote, alternative legal service providers, as if they're a kind of a small element. But, Thomson Reuters estimates they could be $20 billion worth of business and growing, and includes everything from a kind of do-it-yourself market for wills and other sorts of legal services, some of which increasingly are going to be aided by technology. I'll talk about that in a second. To multidisciplinary professional service firms like the Big Four, all of which who have giant legal services operations, not to mention investigation firms or deal evaluation firms or a whole range of other providers. And AI, as I started to say, is turbocharging this alternative sector as well as transforming traditional legal services business. Harvey, many of you know, is probably the most famous new legal tech company, AI provider. It's now valued at $11 billion, right? That's even larger than the most valuable law firm, Kirkland and Ellis, which had $10 billion of revenue last year. And there are many others. Venture capital money is flooding in to this new sector at the tune of $3 billion for legal startups in 2025 alone. And just this week, Anthropic and Claude announced a partnership with one of the biggest, most important law firms in the world called Freshfields, which is one of the Magic Circle firms, to transform this global law firm's operation end to end into an AI-enabled business. Look, in the age of AI, if we're talking about professional independence, who are we talking about? Because figuring out where the humans leave off and the machines that AI begin is increasingly difficult. But it's not just the role of the state that's getting more complex. Role of the market, excuse me. It's also the role of the state. State actors are increasingly intervening in the market for legal services around the world. Look, part of what as we studied when we studied China is that, yes, China has developed a quite sophisticated legal framework and legal market, including some of the largest law firms in the world. And yet, that market is basically totally controlled by what my colleague Mark Wu calls China Inc., meaning it is state control, whether that's the Bar Association itself, which is a division of the Chinese Ministry of Justice, or the creation of powerful law firms like King and Wood, which is the largest law firm in China, one of the largest in the world, which was seeded by the state when it wanted the state to grow a corporate legal profession, to state-owned enterprises and all the lawyers, both public and private, that they employ, and legal education, which is almost exclusively directly a state-owned enterprise, or even private universities are heavily under state control. But it's not just China. In the UK, the government basically took the control over the legal profession away from professional bodies and put it in the form of a government agency. And that government agency basically promptly deregulated much of the structural controls over legal services. So you can have external investment in law firms, you can have multidisciplinary law firms, you can have publicly traded law firms, and many other kinds of market-leaning institutional reforms which were driven by the state. In Singapore, there's a major initiative by the government to transform the Singapore legal profession and to entice outside investment into Singapore through law. And this intervention is increasingly moving from the economic to the political. So much of what has been talked about elsewhere in this series is the rise of what my colleague Scott Cummings at UCLA and others call autocratic legalism, meaning the use of law by governments to undermine the rule of law, and the use of lawyers. And in Trump 2.0, it is increasingly clear that this trend has come to the United States, whether it's executive orders against law firms, requiring law firms to donate pro bono services to things like trade negotiations, or not to do pro bono matters for disfavored causes like asylum cases or in diversity. And when you combine it with what's happening elsewhere in the administration's policy, it's clear that the Trump administration is following the lead of many other countries around the world, in which the state is increasingly intervening in the market to pick winners and losers in order to facilitate the state's ability to win global competition. And as governments around the world increasingly understand the importance of law as what I have elsewhere called a gateway drug, meaning law is an important entry point into gaining control over economic, political, and even social developments around the world. And as we enter a new period of conflict between globalization and deglobalization, it seems clear that the efforts by government actors to push the state gear is likely to accelerate. So, what does that mean? We now have a much more complicated macro gearing world and micro gearing world, in which the state, alternative legal service providers are moving in both directions, influence each other, and pushing globalism and anti-globalism. All right, that's a lot. And it seems clear that it has important implications for the ability of lawyers to act as independent professionals, right? Given these structural realities, it's no longer sufficient, probably never was, simply to urge people to be independent, right? Instead, we need to think about what professional independence means in a world in which lawyers operate under increasing pressure from both the market and the state, and in which professional or traditional professional organizations and even legal education have become either weak or outdated in their ability to understand and influence what's happening out in the world. Look, understanding this is incredibly hard, and I am so lucky that I don't have to try to do it myself. In fact, we have three amazing people who are going to help frame a discussion, and it's only the beginning of a discussion of how we should think about these issues in terms of their own unique experience in the state, the market, and the profession. We're very fortunate to be joined by Dan Yee, who's a senior research fellow at the Center on the Legal Profession, but was a former associate deputy attorney general in the Department of Justice. Lori Alman, who is the chair and managing partner of one of the most important and innovative law firms in the country and the world, Seyfarth Shaw, and Eli Wald, who I'm very proud of because he was my SJD student many years ago, who's now gone on to become a leading academic and is deeply engaged in both studying and thinking about the profession and actively working with the Colorado Bar Association and others. So I'm going to stop sharing my screen, and hopefully all of my panelists are welcome to the stage. And I really want to get this conversation started and to get your sense of where we are. And so, Dan, I want to start with you because so much of the attention has been on the government and on government lawyers and how the changing relationship between the independence of things like the Department of Justice or the judgment of lawyers inside it and the political control, which was always there between the executive branch and the Department of Justice. You were, as they say, in the belly of the beast, and you've been doing a lot of thinking since you've been here with us at Harvard around what this means and how we might restore or recreate or even more reimagine what professional independence means for government lawyers. So could you say a few words about that?
Well, thank you, David, and thank you for AALS for having me, and thank you for everyone who joined today. I just want to get started by really going back to actually a slide that David Wilkins showed earlier, and let's see if I can share my screen. It's just a very important slide, and if anyone takes anything away from today, I think it's this. Really, to me, one of the fundamental questions facing us as a society and as a profession is exactly captured here, which is how should we feel about and respond to this, the state gear here getting really, really big and bringing a lot of torque to the table. And how will the folks who manage and run these firms, we're very lucky to have one of these folks on this panel today, how will they manage all the torque coming from all these different directions now, from competitors, from clients, and from states, and from the state? And it's really interesting because the state, I mean, there was that historical conception of law, both for government lawyers and for outside, which was lawyers do what lawyers do. We represent people who need representing. And for the government historically, it generally respected that. The norm was, at least in the Justice Department, we care about getting justice done, not necessarily winning. And so we actively want and need the best lawyers working for people, even the people we're suing and prosecuting, because we believe it's the best way for the right outcome to happen and emerge out of our adversarial legal system. And I'm going to give you an example of exactly that norm in play in a moment. But then it's shifted from that to something that's a little bit more like, mighty nice firm you have there. It would be a shame if something happened to it. And that's a major, major shift in mindset and approach. And the overall strategy is creating an us versus them dynamic where you're either an agent of the state or you're an enemy of the state. And there can be nothing more, again, to the framing of this conversation, VUCA, there can be nothing more, in my mind, volatile and uncertain as having a political time-limited entity who enters the business calculus in ways that are going to have long-term ramifications on a firm, let's say, far beyond the time-limited term of that particular political entity. And that's, again, why historically we're in a bit of uncharted waters. And that's been through the EOs. That's the clearest example. We don't need to hash. I know that that's been a long-running conversation and people know all about that. But let me just give like one concrete historical example here that I've been thinking a lot about lately, which is the Cully-Simpson case of 2007. Cully-Simpson. So Cully-Simpson was a DOD official. He was a pretty senior official in DOD back in Bush 2. And he gave an interview once to Federal News Network, which is as inside the Beltway a media outlet as you can imagine. He gave a radio interview to them. And he said, we have all these Guantanamo detainees and all these big firms are signing up and volunteering to help these detainees out. Like, clients should really maybe think, if they're patriotic companies, maybe they should think twice about working with these firms that are representing these detainees who are terrorists and they're, flying planes into our buildings, et cetera, right? And the immediate response within, I believe, less than a week, the Department of Defense repudiated what he said and said, we do not agree with what he said. He resigned and he issued an apology afterwards, right? He issued an apology and said, that was basically, I've gone too far. And that was because, I mean, there was this very, very deep embedded belief of exactly that at the end of the day, it's obvious the long-term ramifications of that. And actually, our system relies on basically lawyers doing what lawyers do and representing people who need representing. And I think it's really fascinating. I've been thinking a lot about it mainly because fast forward to today, and the firms that are again kind of in the crosshairs, um, frankly, I have a hard time imagining a less popular client to take on than the Guantanamo detainees. And yet today, the firms that are in the crosshairs are often firms who are just, frankly, just unpopular, politically unpopular with the administration. And that's a major shift. And that's, I think, a really fascinating one that, again, illustrates the growing size and torque that's being applied to that cog.
Thank you, Dan. Lori, you are the one who is still in the crosshairs. You will recall when you got this job, I said congratulations and condolences, and
I recall.
I had no idea what was coming. And how do you think about this? Because it's not just the government, and you could talk about that, but it's also the incredible competition that you're facing and the incredible pressures from clients to do more for less and faster and service and be a business partner and all of that. And now you've got AI coming at you from the ground up. And yet you are somebody I know who cares deeply about independence and thinks it's at the core of what great lawyering is. How, is the leader of an organization like yours, how do you begin to think about these issues?
Yeah, well, thank you for having me, first of all, and thank you, AALS and Dan and Eli. Just great to be here with you. But we try to look at it first through the lens of what's best for our clients, right? That's our purpose. That's a purpose as a practicing lawyers, to do what's best for your clients. But that's not necessarily so clear these days. So that sounds like a nice broad statement, which is true. But then you dig a little bit behind it and you realize there's some complexity even to that point, because you clearly don't want to create short-term risk for your clients. You don't want to wave a flag and say, hey, shoot at us, then shoot at our clients in some way. Our job is not to put a spotlight on our clients because we want to grandstand about something or things like that. But you also have to consider at the same time that you have to think a little bit longer term about your clients and your client relationships. And so, all of our clients are entitled to zealous, fearless advocacy. And they're entitled to know they can rely on the law. They need to know when they enter into contracts that those can't be wiped out because they've said something politically unpopular. And frankly, that could be, it's one political party today, but it could be another one tomorrow. There's a lot of power shifts happening now, and those won't necessarily be ceded if there's a change in which party is in charge. So you have to be thinking about, how are we protecting our clients' interests? The law has to be predictable and subject to predictable interpretation. You definitely need to be supportive of an independent judiciary, because if the judiciary is not comfortable making fearless decisions based on how they interpret the law, the whole system kind of collapses, frankly. So we think about all that, and then you think about the pressure points of, I am running a business too, in addition to running a partnership of professionals. And as you said already, AI creates brand new pressure points on lawyer independence that I don't think anybody thought much about a couple of years ago. Maybe our programmers, but not most of us. And there's this sort of risk of this subtle outsourcing of judgment. The AI platforms are largely created by a handful of companies. And so do you have to worry about training bias or the standardization of outcomes? The more you rely on AI, are you going to get sameness? over and over. And so, and then as you said, this pressure for faster or cheaper outcomes, and that's less deep thinking and less judgment, and that's a pressure point. On the other hand, you have to be cognizant that AI can challenge us to be deeper thinkers, and it can, rather than cognitive offloading, you can say, how can AI make us smarter and make us think harder, and how can it catch our own bias and help us have a broader viewpoint, look at analysis and data that we really didn't have us. So we're trying to navigate that. Where I also think the market. As you said, the market's not new, David, for sure. The market's not new. A lot of lawyers have been getting paid to practice law for a long time. And that was always a factor. It'd be nice to think everyone was just doing this all pro bono, but that's not the reality of how it works. But I do think it's different right now. Partners are getting paid like they're professional athletes these days. And that it used to be a good, strong profession, but it wasn't the kind of thing that you flew around on a private plane kind of job. And there's a reason private equity has never been so interested in laws and asset classes as we've talked about. And private equity's purpose is generally not independent justice and pro bono legal service delivery, right? And so you're going to have these more pressure points. And I know other professions experience this too. We've seen some investment in healthcare, which has driven some different outcomes than what we've seen in the past, and not necessarily positive ones in all instances. But then I'd sort of add another layer that I think is a little bit different for law. Increasingly, whether it's legal media or, just social media or how law students evaluate it, profit has become equated with excellence in law firms a lot right now. I think there's a conflating of, gross revenue equates to excellence, or profit per equity partner equates to excellence. And, I don't know that you see that quite as much in some other professions. If you need cancer care, you probably don't decide, should I go to MD Anderson or should I go to Sloan Kettering? Hold on, let me look at who has a higher gross revenue, right? That just doesn't factor in. You're looking at outcomes, and in law, I think it's become so important. So the more those numbers matter, because that's how you attract the best talent, well, the more transactional everything becomes, the more short-term profit everything becomes. And so maybe you're thinking a little bit, well, right now, what's going to lead to the most money? And that the more you shift towards transactional, I think the more you shift away from independence. So we're thinking about, to answer your second part of your question, how do you really ensure you have a purpose-driven focus within your law firm and your partnership? And we try. It's not easy. None of this is easy, but we try to be very transparent and have a lot of thoughtful discussions about what it means to be zealous, excellent advocates. I think it's important that you have a genuine partnership and not just a sort of eat what you kill kind of environment. Because the more transactional it becomes, to me, the less independent you'll become. You're just going to do whatever it gives you the most short-term game. So we think a lot about it. We talk a lot about it, and I don't have a great perfect answer on how you resolve it all. But I think the more you focus on what is your purpose, why did these lawyers go to law school in the first place? These students go to law school in the first place. You can get back to what we really need to do as a profession.
Well, it's incredibly thoughtful, Lori, and it's a perfect entree to my dear friend and former student and current law professor, Ellie Wald, who is, I think, uniquely positioned to kind of put many of these pieces together, because not only is he one of the leading scholars in the profession, but as I say, he works closely with the bar. And his wife is a leading practicing lawyer who's carved out an incredible practice in green energy in Colorado before anybody had ever heard of it. So, Ellie, you know, I wonder if you might take sort of the bar and legal education as your entree point to talk about these issues, because again, that was supposed to be the thing that would make lawyers independent, right? And uh, they're both under tremendous pressure. So say a little bit about that.
Thank you, David, and thank you to the AALS also I'm tempted to say that rather than answering your question, I just want to turn it back to Laurie and Dan because that was absolutely fascinating. So I'll try to be very brief. And I want to start where, as Dan did with one of David's slides, I'm not going to put it on, but just remind you that David told us that the cornerstone of independence, at least historically, was self-regulation. And if David says, well, Ellie, can you talk a little bit about self-regulation? He told you there are at least 4 arenas of self-regulation we lawyers tend to worry about. We worry about admissions, and we worry about the rules of professional conduct, and we worry about enforcement in them, and we worry about holding the line between lawyers and non-lawyers, and now, as David said, alternative business structures and so on and so forth. And there's a beehive of activity in self-regulation. Just to give you a few examples of what many very smart lawyers, academics and practicing lawyers have been thinking about in terms of self-regulation. Just in the last few years, we all know that we took a step in terms of admission toward moving from state-based regulation to nationalization. We have something called the uniform bar exam. It's a step, some of us think, in the right direction. And in terms of the rules of professional conduct, Laurie mentioned AI, and it wouldn't surprise many of you to know that hundreds and thousands of hours have went into the last a couple of years, and regulators trying to think about whether we need a new rule for AI, or whether the old rule on competence is sufficient, 1.1. And in terms of enforcement, we worry a lot about transparency and about the perception of other enforcement. And when it comes, of course, to minding the line, we see lots of activity in the states in terms of allowing non-lawyers into the fray. David mentioned that the state of Washington was the first to allow legal technicians, to regulate legal technicians. That's in that state, the state Supreme Court sunsetted the experiment, but other states have introduced it on the one hand. And of course, as David mentioned, we see a great transformation on the horizon in terms of alternative business structures and investments in law firms. Laurie mentioned some of that. So, make a long story short, if David had asked me just a slightly different question, how is self-regulation doing? Would have said, oh, it's a beehive of activity, all is well, and it's a well-oiled machine, and it's a whole apparatus, and it's likely to survive. But that's not what David asked. He didn't ask whether self-regulation is alive and well. He asked whether self-regulation is well-positioned to anchor these new challenges of independence. And here, unlike an academic, I want to say it doesn't depend, and in my opinion, the answer is categorically not. Self-regulation, as we know it, is not well-positioned to anchor the new challenges of independence, and here's why. And you've heard it from Laurie and Dan and David, but I'll just paraphrase slightly. Self-regulation is premised on the same assumptions that are no longer true about legal independence. As Dan pointed out and David suggested, the state is a meaningful actor in ways that we couldn't have imagined 100 years ago when we set about to put the infrastructure of self-regulation in place. And we ought to worry, and this is, I think, where the future of self-regulation is, now to finally answer David's question. The future is in trying to figure out what are the public responsibilities of lawyers when it comes to the state. And similarly, what are the public responsibilities of lawyers, not just corporate lawyers, lawyers in general, not just lawyers at big law, lawyers, when it comes to clients. As Laurie pointed out, it used to be true that at least ideally, we had the Elia Roths of the world who came and said that every once in a blue moon, in appropriate circumstances, my job as a corporate lawyer is to tell the client, quote, is a damn fool and should stop. But if we don't think that corporate lawyers are in a position to do so for all the complex reasons that David explained so eloquently, what are the public responsibilities of lawyers? If we had a good understanding of what it means to be a professional, not just a service provider, we might think about self-regulation that derives from those concepts. Because I want to turn it over to my esteemed colleagues, I'll give you just 2 examples and I'll rest at that. Suppose we took the public responsibilities of lawyers seriously, say commitment to the rule of law, say access to legal services. We might see the ABA, just as it was 100 years ago, almost to the day, in the forefront of orchestrating UPL, unauthorized practice of law statutes, We might see, instead of the ABA and State Bar Association and professional organizations, instead of holding the line and resisting state by state changes and deregulation that allow non-lawyers to enter the field, we might see the ABA leading, coordinating the effort to allow non-lawyers to practice law and enter the market for legal services. Or, because I don't want to preach, notwithstanding being a law professor, if we thought that lawyers ought to play a role in greater access to legal services, we might see changes to self-regulation, like instead of aspirational pro bono, we might see mandatory pro bono, and we might see very smart mandatory pro bono. I suspect that an amazing lawyer like Lori, even if she tried really hard, might not find a lot of pro bono clients that she can immediately be matched with and provide legal services with. That's oftentimes true for big law lawyers, but it might be the case that if we have a smart mandatory pro bono scheme, not what we have right now in self-regulation, then 100,000 big law lawyers who charge on average, I've did the math, Lori, you'll have to believe me, $1,000 an hour. If you do 50 hours of pro bono a year, that's $50,000 multiplied by 100,000 big law lawyers on average. That's $5 billion to the Legal Services Corporation if you write a check and don't try to do it yourself. See, there are many solutions if we only took this seriously. So I'll just end by saying this. David told us, that's my second example. David told us that, and the numbers are true and staggering, that the ABA 50 years ago counted 50% of American lawyers as members, and now it's just about 25%. And what's the future of professional organizations? Well, Lori might tell you, if you want her lawyers to pay dues and go spend the time at professional organizations, it might behoove these professional organizations to give a value proposition for Lori and all of the lawyers. What is it that we lawyers as professionals do? Again, what are our public responsibilities vis-a-vis the state, vis-a-vis the market? And if you could just convince Lori and all other practicing lawyers that professional organizations are the venue to go delineate, articulate, enhance, and this understanding of what it is that we lawyers valuably do, we might actually invest time, effort, and money in them. So, long story short, I wish I could tell that the future was bright for self-regulation and professional organizations, but unless we take the independence of lawyers seriously, I'm just not sure that this great, well-oiled machine that will continue to work is a great support for the independence of lawyers.
Fascinating and both illuminating and a little depressing. But Elliot, yeah, thank you. I'm going to ask you, listen, this is a conversation, I promise, I said we're starting the conversation. You can see how rich it is. We only have a little bit time left, and I'm going to ask, starting with Lori and then Dan and then Ellie, because Ellie's already begun it a little bit with professional organizations. I'm going to ask each of you to say what in the domain you know best, which Lori is in great law firms and private practice, Dan, it's in government, and now Ellie, I'm going to ask you at the end to talk about legal education. What kinds of things structurally could we do to try to both articulate what public responsibilities mean in this new world, but then also to help support and reinforce them? So, Lori, can I start with you on that?
Sure. It's such a complex and important question. So I'm sure I will answer it inadequately, but I'll share at least a couple of thoughts. I think, part of it is legal education. It's so good at teaching people how to think like lawyers, and that's fundamental to this whole system of independence. Absolutely, but how to think like a lawyer. But maybe thinking about conversations with students too about, why does it matter that we think like lawyers? What is different about being a lawyer than just being a service provider? there's a lot of talk about legal service delivery and efficiency and cost reduction, and all that's incredibly important. But that's not why we went to law school, and that's not why the students are going now. What we go for now is to help solve complex, complicated problems, to be willing to stand up when something isn't right, to have there's a purpose to why I think most people end up going to law school. If they wanted purely transactional, frankly, law is a very hard way to become the richest person you can be. Most other professions are not charging by the hour, and how you work. So there's a reason that people gravitate towards law school, and we see how many people are gravitating towards law school these days because they see something that maybe think needs some improvement or changing. So I guess I would think about law firms and law schools partnering together to think about why you went into this in the first place and what it really means to be a great lawyer. Does it mean that you work at the firm that generates the most profit? And don't get me wrong, my partners want me to generate profit too, and we do. But is that your only measuring stick, or are you thinking about something a little broader and bigger and more important than that? I would love to see also just law firms and law schools partner more, because we're part of a continuum. Most first years don't come out ready to be running the show. So we're doing a handoff that sometimes could be probably more integrated as we think about this important moment that we're in.
Terrific. Dan?
On my end, I mean, I'm going to echo a lot of what Lori said. I mean, I personally think that the battle for talent is really going to be taking center stage in all of this. Lori was exactly right. Literally this week, I spoke to a friend of mine and I said, it feels like I'm watching the NFL draft, watching partner lateral movement, right? Or NFL free agency, right? And that's because high-end talent really is genuinely quite valuable right now on the market. And that's where all the thinking is that's where the long-term value will still reside in the legal profession throughout all the turbulence and the other gears that are coming in. But I think when you know that, and when you know talent is supreme, well, law students carry a lot of weight in that conversation then. Like, law students actually genuinely, they are the talent of the next generation. They are the next people who are going to be coming up and becoming those NFL free agents, frankly. And I think that is, if those students care about the legal profession sort of retaining this status as essentially being the fifth estate, right, in American society, they have to actually act on that and express that in their choices, which is exactly, I think, what you're hearing Lori say. I'm exactly in line with that. That's it.
Terrific. And Ellie, just very briefly.
Very briefly, Ellie too wants to agree with Lori, and I'll give one example. We don't teach students anymore, if we ever did, about justice. It's important, as Lori said, you go to law school, why? To learn to think like a lawyer, but also why? Because you want to advance, she said it, justice. 200 law schools, and we don't have justice as a required class. And it would be great if we taught our students what it means to pursue justice as a corporate lawyer, as a lawyer in the individual sphere, as Dan said, as a lawyer for the government. If we took it seriously, maybe our students did too.
Well, this is so important and just the beginning. And I'll just close before I turn it over to Austin by saying, if all this sounds like an advertisement for putting more resources on centers on the legal profession of the ones who have put on this series, who are trying to integrate theory and practice, who are trying to understand what justice means in an ever-changing world, then I'm guilty as charged, and I hope it works. Austin Parrish is the immediate past president of the American Association of Law Schools and has really spurred this series. And thank you so much, Austin. Please close us out.
Well, David, thanks so much. And thanks to you, Lori, Daniel, and Ellie for just a fascinating conversation. I just have a couple of quick reminders, a couple of thank yous, and then I wanted to end with some closing remarks. So first, some reminders. Please remember if you're a student watching this that you can obtain a certificate of completion. Never bad to be able to add something to your resume. And we also have a writing contest that is occurring that ALS is sponsoring where you can submit a paper on an issue of professional independence of the legal profession. So I encourage you to take a look at that at the ALS website. Second, a couple of thank yous. So maybe I could end a little bit where David and Lori and others. I would say there's a lot of innovation that is occurring among law schools in this particular area. And I think it's absolutely fabulous, those schools that have centers on the legal profession that are studying these issues in a particular way and emphasizing the importance of justice. And so that leads me to some of the thank yous because this was really the work of a number of leaders at different schools. So a particular thanks to Ann Southworth at UC Irvine for the first program, Deborah Pearlstein at Princeton University for the second program, Tamara Lawson, Dean of the University of Washington, who spearheaded the third program, Jay Krishnan and Cristiano Ochoa in the Stewart Center in the Legal Profession at Indiana University Bloomington's Maurer School of Law for the fifth section, Mitt Regan from Georgetown University Law Center for the fourth section, and lastly, David and Brian Fong from the Harvard Center for this last session tonight. Those are really fabulous schools that are doing really important work, and we are grateful that they partnered with ALS to put on this 6-series program. So I'll just end. I thought this, with a couple more quick thanks and then end with a couple of thoughts. So one, behind the scenes, there was a tremendous amount of work here done by ALS staff, Jim Grief and Zainab Ellen on this one, but more broadly. So thank you to ALS for doing all the work behind the scenes to put on this webinar series. We had over 575 registrants for the 6th series, and we think many more people will go to the website to watch the videos. And we hope you do that. And then also a special thanks to Peter Zuchhauser, who was on the first panel, who spearheaded the panel at the ALS annual meeting, and who really pushed to move this along and has helped us support the student writing competition. So many thanks to Peter for his leadership and keeping this moving along. So lastly, I'll just end. I thought these were 6 fabulous sessions, and I think they reflect sort of some of the things that we need to talk more about as a profession. I really like Lori's idea that we need to continue to connect law firms and judges and the legal profession with legal education more broadly and make those ties greater. The challenges that law firms and law schools and courts face are common, and I think we're stronger when we move together. I'd also encourage you to look at other programs that ALS is sponsoring. ALS is a fabulous organization for convening some of the great conversations. And you'll see on the ALS website not only this webinar, but many other webinars on issues of critical importance to lawyers and law faculty of the day. So thank you for joining us for the last 6 sessions. Kelly, I just want to make sure that you don't want to come back in before I close things out, but it's been an absolute privilege. And David, thank you for bringing us home with an absolute fascinating last session for our 6-part webinar series on professional independence in the legal profession. Thank you so much for everybody who joined us over the last 6 weeks. We appreciate it.
Austin, I'm all set. Just big thanks to you and to David and Harvard and all the speakers. We're grateful.
Thanks, everybody.
Thanks
Bye-bye.
so much for joining us.